Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing Tuesday. Hey, y'all. So, this is an update, a quick update in regards to MilagroGramz motion to dismiss. I've been sick, so I'm behind, so I'm trying to get this stuff out for you guys. So, the judge did review MilagroGramz motion to dismiss, and he put out a order in regards to that on February the 7th. And this motion to dismiss was granted in part and denied in part. And what that means is some things were granted, some things were not granted. The only thing that was granted was the cyber stalking, but the judge ended up allowing Megan Thee Stallion to file a second amended complaint in order to cure the cyber stalking count. Um, Let me see. Ba, 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 ba. Yes. So, and I'm just looking at my notes. So let me pull up the order right quick, and then we'll jump into the second amendment complaint. I'm not going to read all of it. I'm just going to read the cyber stalking because that's all she had to end up curing. So we know that there were a total of four counts: defamation, the deep fake video, the intentional infliction of emotional distress, and the stalking. Now the crazy part is uh the defamation, the motion to dismiss, the defamation count, the deep fake count, and the intentional emotional distress count was denied. Okay, as I said it before, the only thing that was granted at the time on February 7th was the cyber stalking. And it is a reason behind that. If you guys remember me reading the amended complaint, she really did not, when I say she, Megan really didn't outline as to how Milagro was cyber stalking her. She didn't provide enough meat for the judge to say, okay, this would be considered cyber stalking. So what he did is he said, okay, I'm going to go ahead and grant the dismissal for the cyber stalking, but I'm going to allow you to actually uh, amend your complaint, provide me with some substance, and then I will reconsider. And she had until the 18th of February to do that, but she actually ended up filing that yesterday. And so that's what I'm going to get into in just a second. But I want to read the part of the order in regards to the cyber stalking so y'all can understand why the judge granted a partial dismissal for that. And once again, it's because she didn't provide enough meat to it. All right. So here's the judge's opinion on this and ruling. So he says next, defendant contends that plaintiff fails to state a claim for cyberstalking under section 784.0485 of the Florida statutes, arguing that the defendant's alleged conduct does not justify an injunction and that plaintiff has not complied with the statute's procedural requirements. Defendant also urges the court to decline to exercise supplemental jurisdiction over the claim. Here is what section 784.0485 paragraph 1 states. In Florida statute, it creates a civil cause of action for injunctive relief from stalking. Because if Megan um, provided the substance to show and the evidence to show that Milagro was cyber stalking her, then they can consider the injunctive relief. And that in the injunctive relief pretty much states that if it is granted, then Milagro cannot speak on Megan, period. No mention of her on any social media platform. She could holler Megan at the top of her home, but she would not be able to come public on social media to do so. Okay. That's why the judge allowed her I need to start saying names. That's why the judge allowed Megan to amend the complaint to provide an outline as to how she was cyber stalked. Now, under that statute, it does say that stalking occurs when a person willfully, maliciously, and repeatedly follows, harass, cyber stalks another person. Okay. It also says an alteration was added. States a separate section of the statute defines cyber stalking more precisely. So this is cyber stalking. It says to engage in a course of conduct to communicate or to cause to be communicated words, images, or language by or through the use of electronic mail or electronic communication directed at or pertaining to a specific person. And this is causing substantial emotional distress to that person and serving no legitimate purpose. So I want people to take their feelings of what they have of Megan and just look at the law. This is the Florida statute when it comes, and a lot of statutes are similar to this, but this is the Florida statute. So it defines exactly what cyber stalking is. So if you take this definition and you apply to what Milagro was doing, does it fit? To state a claim. So, in order for Megan to state a claim under this cyber stalking Florida statute, the plaintiff must allege that one, the defendant willfully, maliciously, and repeatedly engaged in a course of conduct that involved directly or indirectly communicating or causing to be communicated words or images using electronic communications directed at or pertaining to a specific person that caused substantial emotional distress to that person and served no legitimate purpose. Further, to obtain relief, the plaintiff must file a verified petition alleging existence of cyberstalking and set forth the specific facts and circumstances for the relief is sought. Plaintiff Megan argues she satisfies the standard for cyberstalking because she alleges that the defendant willfully and maliciously engaged in a sustained course of online harassment, repeatedly spreading defamatory statements, using bot accounts to attack her credibility, and direct followers to a deepfake pornographic video. These communications, made through electronic means, were targeted at plaintiff and alleged caused her substantial emotional distress, exacerbating trauma she had already suffered. Plaintiff also asserts that defendant's conduct served no legitimate purpose as it was designed solely to humiliate, discredit, and retaliate against her for testifying against Peterson. Defendants first insist that her statements had a legitimate purpose and that the First Amendment shields her from the liability, precluding injunctive relief. The court disagrees. Plaintiff does not allege mere insults or hyperboles. Rather, she claims that defendant waged a campaign of intimidation and harassment against her. These allegations, taken as true, are sufficient to support plaintiff's assertion that the defendant's conduct served no legitimate interest. Again, this is the judge's ruling. This is the judge's ruling. They disagree with the defendant. Okay. Defendant next argues that plaintiff's petition for injunction against stalking lacks sufficient factual allegations and fails to meet the statute's procedural requirements. On this point, the court agreed. The petition merely states petitioner is a victim of cyberstalking because respondent has committed cyberstalking, and then directs the reader to the amended complaint for further details. That is insufficient. Once again, you got to give them substance. You have to give them facts and examples of how you were cyber stalked. Section 784.0485 requires the petitioner to specifically allege incidents of stalking, including when and where they occurred, and to mark applicable categories such as whether the respondent previously harassed the petitioner. The petition offers no such details. A conclusory assertion paired with a reference to an external pleading is not a substitute for a properly sworn statement. The petition falls short, lacking the necessary detail and failing to provide a sworn account of defendant's alleged cyberstalking as required by statute. Plaintiff all but concedes the point and indicates she will be willing to swear to the allegations she relied on to cure this defect. Uh, the court will permit plaintiff to cure this defect. Lastly, the court declines to relinquish jurisdiction over this claim because it has no discretion to do so. Plaintiff correctly asserts that diversity jurisdiction applies as the parties are completely diverse and the amount of controversy exceeds 75,000. Defendant arguments that plaintiff's cyberstalking claim alone does not satisfy the amount and controversy requirement misses the mark. The diversity statute governs entire civil actions, not just individual claims. Other than plaintiff's deficient petition, which she will have a chance to cure, she has adequately pleaded a claim for stalking under Florida statute 784.0485. All right. So she has to pretty much cure this. And what's the conclusion? So the conclusion was order in the judge that defendant Milagro Elizabeth Cooper motions to dismiss the First Amended Complaint is granted in part and denied in part. Megan has until February 18th to file an amended complaint curing the deficiency in count 4. All right, now going to the Second Amended Complaint. So this is what Megan submitted to court to cure, to pretty much provide facts, times, dates, instances where she was cyberstalked by Milagro. And it reads, defendant has communicated both directly and indirectly a course of conduct designed to cause severe emotional distress to Ms. Pete as laid forth herein. She has done so through electronic means and therefore meets the definition of cyberstalking pursuant to section 784.048 Florida statutes. Accordingly, she is entitled to an injunction against cyberstalking pursuant to 784.048 of the Florida statutes. Ms. Pete, by reference, the attached affidavits as required by statute as Exhibit A. Therefore, Ms. Pete seeks an injunction restraining the defendant from committing any acts of cyberstalking and harassment against her and providing any terms the court deems necessary for the protection of Ms. Pete, including any injunctions or directives to the law enforcement agencies. All right, so let's get to Exhibit A. Oh, let's see. All right, so that just says that. All right, so 11 reads, prior to this action, there were no court cases between respondent and me. However, on October 30th, 2024, I initiated a lawsuit against respondent in United States District Court, Southern District of Florida, in the case number. The First Amendment complaint alleges 4 causes of action against respondent: defamation, promotion of altered visual depiction, intentional infliction of emotional distress, and cyberstalking. I am a victim of stalking because respondent has committed stalking, previously threatened, harassed, stalked, and cyberstalked me, and threatened to harm me. Below is a description of the specific incidents of harassment, cyberstalking, and threats to harm respondent has made against me. And it reads, Respondent is a paid mouthpiece for Daystar Peterson, who conspired with him to smear, harass, and cyberstalk me. The two make arrangements no secret. Mr. Peterson has posted on social media multiple times that MilagroGramz is the realist, and the respondent has stated that she is still on Mr. Peterson's payroll. Even respondent's former close friend Gail King Noor admitted that respondent worked alongside Mr. Peterson and his father to harass me. Respondents' campaign to harassment and cyberstalking began in July 2020 after Mr. Peterson pow me and injured my feet. On October 8, 2020, Mr. Peterson was charged with a felony assault with a semi-automatic firearm, illegal possession of a firearm, and negligent discharge of a firearm for pow-powing me. Respondent began to spread misinformation about me. One example was in May 2022 when respondent falsely posted online on her ex account that it was confirmed that I injured myself by stepping on glass instead of being pow-powed by Mr. Peterson. Respondent continued to spread this false information for months to the point that Los Angeles Times noted she showed no remorse for spreading this misinformation long after it was proven to be untrue. In December 2022, Mr. Peterson's criminal trial began. On December 13, 2020, I testified against Mr. Peterson. Respondent was present with Mr. Peterson's family during my testimony and entire criminal trial, frequently posting online regarding the trial and falsely branding me as a liar and a perjurer. On December 21st, 2022, a week after my testimony against Mr. Peterson, respondent posted a live stream video on her Instagram account where she stated, "At the end of the day, a bitch is lying on somebody is low down. Yes, she got hurt and that's cool, but how you get hurt? How? And what are the circumstances and what after that? So itch, if you think you finna be sitting up here boo-hooing for an itch that played up in y'all face. Not mine, because I've always said her A was lying. Itch, I don't. You think I feel sorry for the itch? I don't. The uh, uh, a itch with my ninja, I'ma slap that hoe, and whatever comes after it comes after it. The respondent again questioned whether I was even pow-powed, said I was lying when I testified Mr. Peterson pow-powed me and threatened me with violence. Additionally, in or around December 21st, 2022, respondent referred to me as a non-credible witness who falsely accused Mr. of a felony. Testifying against Peterson was extremely distressing experience for me mentally, emotionally, and spiritually. I received backlash both online and in the entertainment industry from individuals who, because of Mr. Peterson and respondent coordinated campaign of harassment and cyberstalking, believed that I was lying when I testified that Mr. Peterson powed me. Because of respondent's frequent commentary painting me as a liar, I was depressed, unable to hold conversations with people, and contemplated suicide. Even after Mr. Peterson was convicted on all counts, responded cyberstalking continued, and she persisted in uh uh I don't know what that says, harassing and trying to humiliate me for speaking out about the truth of Mr. Peterson's crime. Like denigrating? The yeah. On January 22nd, 2023, respondent shared a video online where she stated, "I believe this is exactly how they feel about you, Megan. I believe that this is exactly how they feel about you. You know you was a lying a-hoe, and you have absolutely ruined Tori's life." On July 23rd, 2023, respondent shared an ex post that stated he pow-powed her because his ego was bruised. She's the bigger star. That's never been a fact, and dang sure ain't one today. Tory Lanez is behind bars, presumed guilty, getting better numbers in charting. Respondents' posts included screenshots of the Spotify accounts for Mr. Peterson and me. On August 12th, 2023, respondent continued to spread misinformation about the injuries Mr. Peterson caused me when she posted to an X account acting like I'm crazy. Where are the bullet fragments that were referenced as metallic fragments in court and the doctor that took them out? Called an assistant who testified that there was no nerve damage to the stand and said bye. Child, where is the man that threatened her for glass? Now I have a here is the issue with that. And I'm gonna continue reading. In no way, shape, form, or fashion can you call a medical the nurse practitioner, family practitioner, anybody in that medical office, and they provide you with any type of answer about a patient or a former patient. That is a HIPAA violation. That is a HIPAA violation. But anywho's, respondent continued this line of harassment later the day on subsequent X posts where she said, I don't think that Tory is innocent because of anything he did before that day. I can't speak on what a human will do. I think he's innocent because before the waters got muddied, an independent witness saw a fight between two women that they refused to acknowledge after finding out that one had betrayed the other. No one proved who the gun or the pow pow belonged to. His DNA was conclusive, and he wasn't the only one with the pow pow residue on his hands. And every key witness contradict themselves on the stand. These facts are why there's no lawsuit. They exist and validate my stance. On August 27, 2023, respondent wrote on X, it's giving no nerve damage like the doctor on the stand said. Again, falsely claiming that Mr. Peterson got pow pow and injured me. On August 7th, 2024, respondent wrote on X, was Megan Thee Stallion caught trying to deceive the courts again? Again, she falsely accused me of lying about being Mr. Peterson. Even while Mr. Peterson is behind bars, he has coordinated with the respondent to disseminate false information in support of his appeal to cast me as a liar and to hurt my reputation and credibility. For example, on October 28, 2024, respondent falsely claimed on X that the pow pow and bullet fragment evidence from Mr. Peterson's trial had gone missing in support of the false narrative that Mr. Peterson did not pow pow me. Respondent then posted a different X post the same day stating, can you even prove that you were pow pow? Even though Mr. Peterson was convicted of pow powing me, respondent will not let up and continues to spread the false claim that I was not even pow powed in the first place. The consequences of respondent's conduct has caused vast swaths of her followers to attack me online after respondent made her October 28th, 2024 online statement about the missing pow pow and bullet fragments. I received a flood of negative comments from her followers, including, and everybody who defend that lion beast said, well, he went to jail for pow pow possession, but this entire time there was no pow pow, shaking my head. Or, so she ain't but wait, so she ain't no bullet fragment foot AB, but a glass fragment foot AB? Or no pow pow, no bullets, no case. This been old news, and that's how I don't understand how this man was convinced, but the main evidence was missing. In a separate post, respondent made on October 5th, 2024, when she questioned who pow powed Megan, people responded by saying, everybody walking on eggshells around Megan because they're afraid of offending this angry black woman stereotype. Most are Rock Nation bots and bullies. Actual victims don't behave this way. Close friends and the industry peers know she's a compulsive liar. We all know she's lying. Megan was never pow pow. Tory lawyers clearly worked for Rock Nation. Nobody believes Tory pow powed that horse. They mad Tory been out streaming her all year and the public still rock with him. Tell Marcus post her Spotify rap this year. I guarantee you Tori did more streams all while being shot. Meanwhile, she's plastered on the front page. It was not until November 19, 2024, after I initiated my lawsuit against her, that respondent finally admitted that her statements that the pow pow and bullet fragments were missing were false. Respondents' ongoing campaign of harassment and cyberstalking were not limited to branding me a liar. Respondent has gone as far as calling me legally retarded and needing a legal guardian in an alcoholic who comes from a long line of alcoholics. For example, on January 29, 2024, respondent wrote on X that I was effing my manager, T. Ferris, who she described as my guardian. Later that same day, respondent said that I needed a guardian. Then on July 30th, 2024, respondent took her insults a step further and asked if I was ever deemed like legally retarded or otherwise been listed as a capable person. On November 3rd, 2024, respondent called me a drunkie and questioned whether my liver even functions well. October 30th, 2024, respondent stated of drinking seemingly running through my family. According to respondent, I come from a family of alcoholics. In the same post, respondent continued, because the fact of the matter is, you have a grandfather that was an alcoholic. Your daddy, was your daddy on drugs or was he in and out of the system? What was that for? Do you want to talk about that? Is stealing worse than drugs and shit? Respondent references to my family caused me extreme mental anguish. I have been very public about the loss of their and mother and the depression their death caused me. Respondent made these statements to attack my grief, belittle my family, and bring me shame to my family. Respondent had no reason to bring my family into her vendetta against me, other than to harass and humiliate me. Respondent's campaign of harassment and cyberstalking includes the promotion of altered sexual depiction of me. In or around June 2024, an artificial created video of me purportedly engaging in X acts circulated online. Video was undeniably false. I did not consent to or have knowledge of its creation. On June 8, 2024, respondent liked an X post that featured the deepfake video. By liking the post became archived on respondent's likes page, which was accessible to any third party X user at the time. Later that day, respondent made an X post that stated, "Go to my likes." Many of the respondent followers followed her advice and viewed the deepfake video from her likes page. Indeed, at least one news outlet reported that the deepfake video gained popularity after respondent liked the deepfake video post and encouraged her followers to view it. Respondent acknowledged in a live stream that same day that if y'all want to be mad at something, this is what I'll give you. Be mad that I drew attention to it, referring to her conduct and promoting and directing her followers to the deepfake video. The following day, on June 9, 2024, respondent confirmed during her live stream that she told whoever follows me on social media to go to my likes to see what it is that we're discussing. Respondents' harassment and cyberstalking has caused me great pain, humiliation, suffering, fear, and mental and emotional distress. After I was pal by someone I trusted and considered to be a close friend, respondent and Mr. Peterson publicly humiliated me, dragged my reputation through the mud, and subjected me to a campaign of. Respondent's conduct has perpetuated my depression, pushing me to the point where I didn't even feel like making music anymore. I was in such a low place and I didn't even know what I wanted to rap about. There are times where I'll be backstage or in my hotel before a show and I'll break down in tears, only to have pull myself together and be the Megan the Stallion. Respondents' campaign of harassment and cyberstalking has only worsened my trauma and depression. Respondents' harassment and cyberstalking has also negatively impacted my daily life. I am the target of hurtful, angry, offensive, humiliating, racial, and gender based hate made an online post by the scores of respondents' social media followers who parrot her lies and misinformation and attack me on a daily basis incessantly. I have trouble eating and sleeping. I'm afraid to go out in public because I fear that one of the respondent's followers will recognize me and attack me physically or verbally. I still have suicidal thoughts. As I stated in my recent documentary, I would rather not live through this pain. Oh, I'm sorry. I would rather not live through this than to have to live with this. When I filed my lawsuit against respondent, I thought her harassment and cyberstalking would stop. Instead, it has only emboldened her to continue to attack me. I am hopeful that my request for an injunction will put an end to respondent cyberstalking and allow the both of us to move on with our lives. I asked the court to enter in an injunction, immediately restraining the respondent from committing any acts of stalking, cyberstalking, or harassing against me. Restraining the respondent from committing any acts of stalking, cyberstalking, or harassment against me. Providing any terms the court deems necessary for the protection of a victim of cyberstalking, stalking, and harassment, including any injunctions or directives to law enforcement agencies. I hereby I understand that by filing this petition, I am asking the court to hold a hearing on this petition, that both the respondent and I will be notified of the hearing, and that I must appear at the hearing. I understand that if either respondent or I fail to appear at the final hearing, we will be bound by the terms of any injunction or order issued at the hearing. Under penalties of perjury, I declare that I have read the foregoing document and that the facts stated in are true. I understand that the statements made in this petition are being made under the penalties of perjury, punishable as provided in Section 92.525 of the Florida statutes. Signed, Megan. So, there you guys have it. So, the court is going to review this. And if he or she, I don't know the judge, but if he or she deems that the second amended complaint is sufficient and he accepts um the facts that were provided, it's going to be up to him whether or not he deems that those facts are sufficient enough to prove cyber stalking. If he does grant it, then they're going to have a hearing on the injunctive relief, in which it's kind of like a restraining order. You can't mention somebody's name on social media, period. If you violate that, then there are consequences and stipulations according to that particular Florida statute, that 784.0485 statute. So I know everybody is kind of, on the fence with this one. There's people out there that don't like Megan, and there's people out there that is rooting for Megan. At the end of the day, by law, the court deemed that they allowed her to amend the complaint to add specific facts in regards to how she was cyber stalked. And now it's going to be up to the court to say, okay, these facts do coincide with the Florida statute, and we're going to proceed with an injunction relief. But y'all tell me what y'all think about this in the comments below. Do not forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.